Greetings, my name is Angelique Thick. In this video, my group and I will be critically discussing if Section 375 of the Malaysian Penal Code is satisfactory in protecting women from the crime of rape in Malaysia, along with making suitable proposals for reform in the areas of the law that are regarded as not satisfactory. Before we start on that, I'll be showing the provision of Section 375 in the Malaysian Penal Code, which defines the offence of rape in the context of Malaysia. It is stipulated that a man is said to commit rape who, except in the case hereinafter accepted, has sexual intercourse with a woman under circumstances falling under any of the following descriptions from subsection A to G. We'll be critically dissecting this video into 5 key issues within Section 375 of the Penal Code, which we have found to be worth discussing. Then we'll suggest necessary reforms for each of the respective issues. Firstly, the issue to be critically discussed in Section 375 of the Malaysian Penal Code, hereafter referred to as the Code, is the specific insertion of the words of man and woman. This gender-specific section indicates that only a man can rape and only a woman can be a victim of rape. Thus, it is submitted that this section is unsatisfactory in protecting women from the crime of rape, as the technicalities involving gender is complicated by transsexuals, and the scope of this section does not protect victims of female perpetrators. In Malaysia, an individual's gender is based on the gender stipulated in their my card or birth certificate. In the case of Christy Chan and Ketua Pengarah Jabatan Pendaftaran Negara, applying the case of Corbett and Corbett, affirm that a person's gender is the one assigned at birth. So any form of gender reassignment surgery does not redefine the gender of an individual in law. So take for example, if a transgender female is raped by a man, she will not be a victim of rape under Malaysian law as much as her external physical features or mannerism associate with a female, because she is not legally a woman. Similarly, if the perpetrator was born a female but has undergone gender reassignment surgery to obtain an anatomically functioning penis, and he forcibly penetrates a woman's vagina, the law in Malaysia will decide that no rape is committed because the perpetrator is biologically a female at birth. The exception to this is only if the transgender individual, after the surgery, successfully applies to the courts for declaration under the Specific Relief Act 1950 that his gender had changed to her, as per the case of Tan Poi Yi and Ketua Pengarah Jabatan Pendaftaran Negara. Accordingly, it is indisputable that Section 375 of the Code is a gender discriminating provision which fails to protect the transgender community in Malaysia. This is evident as seen in an incident in Malaysia where a transgender female was forced to provide sexual favors to the jail warden in exchange for his protection from being sexually abused by her fellow inmates, was not considered a victim of rape under Section 375 because she was born a male. Hence, the first proposed reform is to neutralize the definition of rape under Section 375 of the Malaysian Penal Code in regards to gender by removing the words man and woman in Section 375. Malaysia should emulate Thailand and the UK, in which both jurisdictions use the gender-neutral word any person as seen under Section 276 of the Thailand's Criminal Code and Section 1 of the UK's Sexual Offences Act 2003. Hence, the courts can focus on the substantive crime of rape instead of being detracted by the debates on the technicalities of parties' gender. Furthermore, Australian court found a female nurse guilty of rape under Section 349 of the Queensland Criminal Code Act 1899 for raping another woman in a hotel washroom in Brisbane. Therefore, Malaysia should also adopt this approach by the Australian courts and legally recognize that women are also capable of raping other women. Thus, it is noted that this reform can only be put into effect if supported by the next proposed reform. That is all from me now, and I will now pass my time to my next group mate, Jenny. Thank you.
Thanks, Angelique. My name is Lim Susian. The next area to be discussed under Section 375 concerns the actus reus element of rape pertaining to sexual intercourse. The explanation under Section 375 provides that penetration is sufficient to constitute sexual intercourse. Indeed, this explanation provides a certain degree of certainty as to when sexual intercourse begins, where a slight penetration will suffice, as held in Sidet bin Ludan against public prosecutor. However, it is unclear whether the penetration is a continuing act from entry to withdrawal. If a case similar to Kaitamaki were to arise in Malaysia, it is possible for the court to rule that rape was not committed if a man continues even after revocation of consent by the woman during sexual intercourse, as the provision is silent on this issue. Therefore, this may be used as a defense by the perpetrators to justify their actions, which would have been considered rape in countries like the UK and Singapore. Besides, the Penal Code specifically provides for non-consensual oral and anal sexual intercourse under Section 377C. Hence, this will not be considered as rape under Section 375, which is only limited to vaginal penetration. While majority cases for the offense of rape involve vaginal penetration, it is unjustifiable why non-consensual oral and anal penetration should not also be considered rape, because these acts are as traumatizing as vaginal rape and equally, if not more, psychological harmful to women. Although it is arguable that Section 377C does offer protection to women against non-consensual oral and anal sexual intercourse, the law should not differentiate between these forms of sexual intercourse and should not be seen as a less severe crime than rape because all of these are non-consensual, as seen under Section 375 of the Indian Penal Code, which forms the basis of the code. The phrase sexual intercourse refers to penetration by the penis as held in Nasrul Anwar bin Abdul Samad. However, Section 375 does not explicitly state whether the offense of rape is limited to penile penetration or whether it encompasses non-penile penetration, which includes penetration by foreign objects and other bodily parts besides penis. In Bunya Anak Jalok against public prosecutor, the accused impregnated a 15-year-old girl but nonetheless got acquitted on the offense of rape because the penetration of vagina was done by fingers covered in semen instead of penis. In light of this judicial decision, it is clear that Section 375 is only meant to cover penile penetration but not penetration by any other bodily part or foreign objects. This case has caused widespread outrage among the public and legal fraternity due to the injustice suffered by the victim and the unsatisfactory state of the current rape laws. The judges in this case have also acknowledged the need for changes to be made to the definition of rape and has called for amendments accordingly. The case would have been decided differently today due to the recent amendments made to Section 377CA, which criminalizes non-consensual penetration by any bodily part other than the penis. Besides, the use of sexual objects, such as sex toys, to penetrate a victim without their consent can be just as brutal and traumatizing as rape. However, penetration by foreign objects and other bodily parts is still not considered as rape under Section 375. Hence, it is essential to protect women from all types of non-consensual penetration. In summary, the current definition of rape under Section 375 clearly falls short in providing adequate protection to women against rape. It is proposed that the definition and scope of rape should be widened, as rape represents an expression of power and violence to terrorize and humiliate women. Hence, Malaysia should consider adopting the amendments made to Section 375 of the Indian Penal Code. Alternatively, this would involve expanding the current explanation under Section 375 to penetration of the vagina or anus with any bodily part or object, or oral penetration by a sex organ of another person is sufficient to constitute the sexual intercourse necessary to the offense of rape. Additionally, a new explanation should be added under Section 375, which provides that penetration is a continuing act from entry to withdrawal. Lastly, it would be necessary to eliminate Sections 377C and 377CA to avoid redundancy. This proposed reform will definitely provide a better protection for women against the crime of rape. That is all from me, and now I will pass on to Zitian. Thank you.
Greetings, my name is Ko Zitian. I will be presenting in respect to the inadequacy of the current laws in protecting women from marital rape, why it should be criminalized, and some proposed reforms. Marital rape is not a concept that exists in the Penal Code, as the exception to Section 375 clearly provides that the definition of rape is not applicable to marital sex. Section 375A also does not come close to criminalizing marital rape. The section merely creates a new category of hurt and does not attach any importance to whether the wife has given her consent. Not only does this negate the importance of consensual sex within a marriage, it is well acknowledged that rape can occur without threats of injury or death. Furthermore, there is no minimum term of punishment for the offense under Section 375A. It can hardly be said that such a light sentence can act as a deterrent for such behavior, in comparison with the minimum term of 10 years for rape. It is clear that the law takes domestic sexual violence more lightly than it should. The justifications for marital immunity stems from the patriarchal norm that the wife gives her consent by virtue of a matrimonial contract, therefore cannot retract such consent. Professor Glenville Williams strongly disagrees, calling this stance insufferable and raising a strong argument that while a wife accepts a sexual relationship with her husband through marriage, it is not a sexual relationship that has no limits. He further states that a wife who refuses her husband's sexual advances should have the backing of the law. The attempt to criminalize any injury caused to the wife by way of coercing her into sexual intercourse does little to protect married women from detrimental psychological damage that come from being betrayed and disrespected by one's partner. As married couples almost always cohabit, the wife faces the fear of such behavior being continuous, and she has to face her perpetrator every day in her own home. Victims are also unlikely to seek help from families and friends out of shame and social stigma around sharing something so intimate, not to mention the prevalent culture of victim blaming. The fact that the law does not criminalize marital rape reinforces the patriarchal and nonsensical notion that husbands cannot rape their wives on the basis of a fictional idea that consent is secured indefinitely through marriage. It is argued that women's basic rights are violated when sex is forced on her, regardless of the relationship between the victim and the perpetrator. Rape undermines not only the autonomy of the individual, but also her dignity and personhood, whether it is committed by a stranger or somebody she loves and trusts, such as her husband. For reforms, it is proposed that Malaysia should adopt the English position, which outlaws marital rape, as seen in the case of the King against R, by first abolishing the exception to Section 375 and Section 375A entirely. It is recognized that marital rape is a unique crime whereby the witnesses are the spouse themselves, their children, or close family members. Hence, while legislating is the crucial starting point, other reforms needs to be focused on enforcement. It is proposed that the entire justice system should utilize the approach of restorative justice as opposed to the traditional retributive justice when dealing with offenders of marital rape. Most wives prefer not to see their husband in prison as it affects their financial stability and the needs of their children. Hence, a suggestion is that offering therapy or counseling instead would be more effective and promote change in the husband's behavior, which also aids in the victim's healing and recovery from the psychological trauma. With that, I shall end my presentation here. Thank you. I will pass the floor to Manlin.
Thank you, Zitian. In recent years, the courts are not hesitant to impose heavier sentences on statutory rape. In 2023, a swimming instructor was sentenced to 263 years in prison and 20 strokes of cane for raping his 13-year-old stepdaughter. This can be contrasted with a case in 2004 where a bapa angkat raped his stepdaughter but was merely charged with 10 years in prison.
Through this, it is clear that there has been an improvement in the application of statutory rape law in protecting young women under 16. Statutory rape is a specific offence of aggravated rape under Section 375, subsection G, which mandates a higher sentence as compared to rape. However, this does not seem to be a sufficient deterrent as women under 16 still form a substantial proportion of rape victims. This may be due to certain limitation to the effectiveness of statutory rape law. On one hand, the law recognizes that women under 16 are incapable of gaining informed consent and should be protected from sexual exploitation. On the other hand, Section 8 of the Islamic Family Law Act allows Muslim women under 16 to be married off with the permission of Sharia court. This loopholes allows perpetrators abusing child marriage law to avoid statutory rape charges. In such situation, it is obvious that no protection is afforded to Muslim women under 16. Second, in Rosie bin Ramli, the court took into account the accused's knowledge of the victim's age when he was found guilty of statutory rape. This seems to imply that if the accused claims he is in good faith, believe the victim is 16 and above, he may be awarded with a mitigating sentence. However, difficulties in proving a person's birthday is no longer an issue since 2001. The act of failing to exert minimum effort to verify an individual's age through the identity card prior to having sexual intercourse shall not claim he had acted due care and attention. Such defense has been eroded with equivocality. In Malaysia, a minor is defined as a person under 18. This means that a minor cannot consent to sexual activities such as sexual touching because it would amount to sexual assault. It is observed that there is mandatory protection of a child from sexual touching, but none for sexual intercourse with the same age. In short, it is nonsensical that a child below 18 but above 16 can consent to sexual intercourse but cannot consent to sexual touching. Sexual intercourse would definitely involve sexual touching. Moving on, the number of reported statutory rape cases involving underage couple is disturbingly high. It is argued that the court should not mete out the same punishment for young men who are in love and adult sex predators who seek to sexually exploit young girls. It is important to note that there is often no coercion or violence involved in cases of underage couples. It is important while providing sufficient protection to women, the law does not tilt its balance as against the accused. To address this limitation, it is suggested that to avoid exploitation of child marriages, Section 8 of the Islamic Law Act should be amended to age 18 and above. Second, it is proposed that Section 79 of the Penal Code should not be a defense for statutory rape charge. Strict liability should be imposed. This will to a greater extent provide better protection to women under 16. Further, the law on the age of consent should be standardized. It is worth referring to the Indian Penal Code, where the age to consent to sexual intercourse is 18 years old. This would be consistent with the definition of a child under the SOACA 2017. Every person is equally entitled to be protected by a law without discrimination. It is proposed that Romeo and Juliet law can be taken into consideration to apply in limited situations where the accused is not much older than the underage victim, so as to not disproportionately punish young boyfriends whose actions are motivated by love and affection rather than perversion. Some additional reforms to combat the prevalence underage rape would be to start criminalizing rape jokes in classes, because this culture is detrimental to the safety of women as it facilitates rape, victim blaming, and discourages women from voicing out any sexual abuse.
Thank you, Malit. My name is Sharon Wong, and I'll be discussing on the law of consent in the context of sexual offences. My discussion will focus on the technical shortcomings of the concepts of Consent and mens rea in the Code, the practical applications of these provisions in Malaysian courts, and some proposed reforms. A positive definition of consent cannot be found in the Penal Code, but one can find the circumstances in which it can be negatived, provided by both subsection C to F of section 375 and section 90 of the Penal Code. It is submitted that when the two sections are read together, the language is inconsistent. To illustrate this, section 90 first mentions that there is no consent if it was given under fear of injury or misconception of fact. Then, section 375 proceeds to provide that rape is committed if the intercourse occurs with her consent, but the consent was given under fear of hurt or misconception of fact. Not only is there a duplicity in the circumstances addressed, by virtue of section 90, there should simply be no consent in such circumstances. To say so would be a distortion of language, as aptly put by textbook author Stanley Yeo. Following the point on duplicity, it is submitted that subsection C is already encapsulated in subsection 90 sub A, and subsection D could fall under the umbrella of misconception of fact. Likewise, section E is also covered under section 90 sub B. To avoid redundancy, the numerous situations under section 375 sub C to F should be abolished, and any additional points should be provided for under a general provision of consent, such as in section 90 of the Singapore Penal Code. It is noted that the vitiating factor misconception of fact covers fraud and misrepresentations of all kinds, contrary to the narrow approach under English law, which is limited to only misconceptions as to the identity of the person or the nature of the act. This wider scope affords women more robust protection in situations where the victims are cheated or lied to just to obtain their consent. Moving on, section 375 makes no mention of the mens rea. However, it is a basic principle that an act is not criminal unless accompanied by a guilty mind. In requiring the intention to rape, the defense that the accused believed that there was consent would negate this intention. Hence, the point of debate is between whether this belief of consent merely needs to be honest or must it be reasonable. Malaysian courts have managed to strike a middle ground between the two, and in doing so have raised the protection for women by limiting this defense. Firstly, the judge in the case of Teo Eng Chan highlighted that the law on consent and misconception of fact can be found entirely in the Penal Code, and impliedly rejected the approach applied in Zainal Abidin and Morgan. The court in Teo held that the defense is stipulated for under section 79 of the Penal Code and is subject to a belief in good faith, which requires that the accused take due care and attention. This introduces an element of reasonableness into the judicial standard of belief imposed, which bodes well for the protection of women from rape. Lastly, in considering the mens rea of the accused through defense elements rather than offense elements, shifts the onus of proof onto the accused. It is for the accused to prove, on the balance of probabilities, that he made a mistake and that his mistake was made in good faith. Hence, it is submitted that the courts have taken an approach that prioritizes protecting women without upsetting the balance between the rights of the victim and of the accused. However, it is still necessary for Parliament to expressly provide for a requirement of a reasonable belief under Section 79 to avoid inconsistent decisions or decisions that may depart from the current stance in Teo. That is all from me.
In conclusion, Section 375 is effective in protecting women from the crime of rape to a certain extent. However, there are limitations and problems, as elaborated on earlier, that require reforms to be made in order to provide better protection for women from rape, while still taking into consideration the rights of the accused under criminal law.